So there's a lot to cover. So I'm going to be sort of reading this because I don't want to forget anything. But if I talk about something that you don't know about, like if I mention something you don't know, please ask a question in the chat. And if you have a more general question, wait till the end so I can get through everything if that's okay. Because this is a vast subject. This is a subject that people spend their lives studying. And so there's just like so much material. It's unbelievable. The story of the medieval legal system is the story of the development, spread, and elaboration of the common law. Common law as in law in common for everyone in all of England, not as in ordinary. So common law is the king's law, with the king and his administration being the unifying authority in England. Unlike most legal systems, for example, the Napoleonic system or the Roman system, it evolved into shape by accretion over time. Originally in England, there was no law as such. Disputes and problems were solved case by case by local communities and leaders. In England, these local gatherings were called moots, first mentioned in 8th century Kent, but even then described as ancient. Anglo-Saxon England, just before the conquest, was divided into administrative areas that also handled what we would call legal matters. Villagers or vills usually held moots which managed minor matters, notably things pertaining to the open field farming system. Does everybody know what the open field farming system is? Okay, great. It was already in Anglo-Saxon times the usual agricultural arrangement. It was a self-contained jurisdiction that managed those sorts of things, and little things like ale, whether the ale was good, stuff like that. The tithing, 10 families with a leading tithing man, and hundreds. Hundreds are a group of 10 tithings, although over time they became to be geographical as well. Hundreds held monthly meetings, collected taxes for the king, and twice a year, the meeting would handle judicial matters. Like threats to the peace, and the renewing of frank pledge was where each of the tithings would pledge to keep the king's peace until the next meeting. Decisions in these moots relied on folcrit, F-O-L-C-R-I-H-T, which translates as the custom of the people. And that custom depended on where you were in England. So different areas had different customs. And so therefore would have like different things would happen in the same situation. This would be determined if there was some question as to what the custom was. There was a thing called time out of mind, which is an expression that we've probably heard. But at that time, it meant a very practical thing. If you had a question of what was the custom, you found the oldest person in the tithing or in the area, and you went and asked them how it was done when they were, as soon as they could remember. And then that was said to be how it had been done for time out of mind. So if the moots couldn't settle a matter just by negotiation or by neighbors talking to people, judgment could be referred to divine judgment by ordeal. Hot iron, which is where you're burned with a hot iron and it's wrapped up, and if it festers, God's decided against you. Hot water, which is boiling water doing about the same thing. Cold water, where there's a pond and you're thrown into it, and if you sink, God agrees with you, and if you don't, he doesn't. Or oaths on relics with oath helpers. You'd have like your friends come in and they would take an oath on the relics that you were telling the truth. No written records of these courts were kept in any systematic way, so they didn't develop precedent just because they sort of didn't know what had happened. The Anglo-Saxon kings had imposed central control by appointing reeves to preside over hundreds and organizing hundreds into shires or counties, as we now know them, who also had a shire reeve, which is where the term sheriff comes from. It's an elision of shire reeve. The king's reeves were charged with seeing that the folcrit of the local area was honored. Boroughs, which are towns, were granted their own moots, which were called hustings when they were held indoors, which is an elision of house things. And they still have hustings in England. So that's where it comes from. And they were a separate jurisdiction from the hundreds, even if they were geographically contained within them. Hustings often focused on mercantile matters because they were in the towns where all the merchants were. And that was the major activity in the town. London is, of course, the largest borough of all. And its husting was the equivalent of a county court or a shire court. It was divided into wards, which were the equivalent of hundreds, and had monthly meetings like the 100 did. By the end of the Anglo-Saxon period, there were the beginnings of the idea of the ascendancy of the king in legal matters. The king granted jurisdiction in writing to boroughs, hundreds, and shires, and sent reeves to oversee them, to enforce the fulcrum. Although there were no specific procedures, the seeds of the idea of the appeal of misjudgment to the king and his council were there. That's sort of why the reeve was there. Does the king need to decide this directly? Anglo-Saxon kings are believed to have issued writs. Writs are written orders from an authority for someone to do something specific, to engage some action. That's what it's called, a writ, because it's written rather than a spoken order. For example, we've all probably heard of a writ of habeas corpus. We still have those. And that is an order to whoever is holding them that they produce the specified body or person in court. So that's an example of a writ that still runs. Writs were not an ordinary part of Anglo-Saxon legal or administrative governments, but they did have them. Okay, so the conquest. Immediately after the conquest, King William promised his new subjects that they could keep their old laws. So the Normans left most of the organization of the country in place with themselves at the time. And those local courts could continue to follow the fulcrum. The Normans shared with the Anglo-Saxons the idea of the regii, which is the court of the king, meaning actually the king's court with his courtiers and his advisors could sit in judgment over legal matters. And they thought, and it was thought to be sort of the last word, so to speak. Village moots tended to be subsumed by manor courts because the manors were taken over by Norman nobles. So they substituted their own personal courts for what had been village courts. But they still continued to enforce the customary agricultural arrangements. If you were a peasant at the time of the conquest, it probably didn't really matter that much. Your lord had a different name. And there was a lord sitting in judgment at the local court, but it probably didn't make that much difference. Some larger landlords also had seigneurial or honor courts that would cover a larger area and had more rights. Tithings and hundreds continued to meet and function more or less the same, with a change of personnel in the sheriffs and reeves. There were three major legal traditions followed in England at this time: the law of Wessex, the law of Mercia, and the Danelaw. But even within those areas, the specific traditions of localities could vary widely. So you could be in one village and the next village over could have a different legal arrangement about things because that was the custom there. Important Norman innovations were the addition of the ordeal of trial by battle, as well as the splitting off of ecclesiastical courts to preside over what were seen as religious matters, such as marriage and wills. Wills are not civil legal matters at this time, they're religious matters, and they're filed with the church courts, and the church courts enforce them. The most fundamental change to law after the conquest was to land tenure. Because William claimed the kingship by conquest as well as right, all the land of England belonged to him. Some of the land was retained by the crown as royal domain. Some areas were designated as royal forests, which had their own very draconian legal code. No one else really owned any land. While this had little effect on the peasants, as I have mentioned, who continued to work the land, for the feudal hierarchy, everyone was a tenant, either a tenant in chief, like earls and dukes and things, who held directly from the king, or subtenants who held from other tenants. At first, tenancy was granted on a martial basis. So land was held to support the marshaling of troops. So you got enough land to support however many troops you were supposed to be marshaling for the king. So a tenant in chief had land that could provide an army and a host of knights. His subtenants would have lands to support, a couple knights if that's what they were expected to give. And under this system, tenants don't have any right to hold land, and land was not inheritable because you just held that land in order to provide this thing for the king. So there's no reason to believe that your descendants, the king has to decide whether they can provide this service to him or not. The overlord granted the land and had to again grant the land to the new tenant, one who could perform the duties on the death of the old tenant, which is the origin of death duties, because you have to pay the death duty to have the overlord let your heir in. This strict martial organization changed rather quickly. Before long, it was expected the children would be seized of the lands of their fathers. And also people wanted to give land to the church. And so it became usual to substitute money, rent, or some kind of service rent instead of direct military service. And it became normal for property to be inherited by children. However, land could not be willed and could not be willed throughout this period. Another innovation that would set the seeds for further development was the preparation of the Doomsday Book. Now, does everybody know what the Doomsday Book is? Okay. Although it was principally a vehicle for taxation, in order to enumerate all the property of England, real and chattel, the commission ended up having to settle disputes along the way. This set the precedent of the king's representatives traveling into the country and dispensing the king's judgment, separate from the king, because the king was in Westminster somewhere and they were out in the country deciding who owned a piece of land, so who had to pay the tax. In general, the early Norman kings continued the trend of the Anglo-Saxon kings of exerting more control over legal matters throughout the country. They issued more writs to sheriffs and reeves, and the kings themselves or their designated counselors would decide matters in their court, especially disputes between tenants in chief, or to right miscarriages of justice. In the period after the conquest, there were no English lawyers as such. There were canon and ecclesiastical lawyers in the church courts, but they dealt with canon law, not the law of the English courts, which was codified in books and things. Litigants in English courts were expected to represent themselves, and there wasn't a complicated body of legal precedent yet, so it was pretty easy to do so. It was your local custom, and they were your neighbors, and you were discussing things and figuring it out. There were no professional judges. Legal decisions were made by the king directly, or by, as I said, by the groups in these moots, or by the lord of the manor. And when he had to appoint, and when the Norman kings appointed justices or justiciars, as they did, who they gave the authority to make judgments in their stead, they tended to be great noblemen or members of their household. Sometimes major churchmen, bishops were often appointed as well. Major landowners had stewards or reeves who managed their affairs and who would take care of any sort of legal matter as we understand it, because they still weren't very complicated. The next great wave of legal innovation came under Henry II. He came to the throne facing great difficulties. His ascension was the ultimate resolution of the protracted, evil, ugly civil war between his mother, Empress Matilda, and his uncle, King Stephen. So Henry's first focus was try to return peace and order to the country. To do this, Henry instituted the heirs. Heirs are a system where judges ride out into the country and regularly hold courts at designated places at designated times. Henry appointed judges at this time, right? They were not set out on a set schedule, but when there was need of them. The first couple of heirs introduced groundbreaking changes in procedure. The heir of novel decisian. Novel decisian is a new, hence novel, seizing of another's property, decisian. Decisian is when you are in control of a property, so decisian is when it's been taken from you. Not only were juries introduced to decide facts as an alternative to battle. This is the first time juries appear. But cases were begun with a new kind of writ, a returnable writ. Previously, writs had ordered, usually the sheriff, to order someone to hand over a property. The new returnable writs were issued so that the sheriff would order the person to turn over the property or come to court on a specified day at a specified time and explain why they hadn't. And so that started a court case, because then you knew everybody was going to be in there would be talking about the problem. This first returnable writ was followed by others. Another early writ, for example, was mort ancestor, a writ claiming that the immediate heir of the previous tenant had been denied seisin. So like your child, somebody had come in and taken your land and the child hadn't been able to take it. Each type of writ addressed a very specific wrong and had to be returned to a specific court because it says where you have to go with it. The heir of Clarendon was organized to deal with the backlog of criminal cases. It introduced juries of presentment, analogous to a grand jury, to indict the accused. Both the civil juries and the juries of presentment didn't operate like modern juries. They were both made up of worthies local to the matter. Whatever the matter was being discussed, they had to be local because they were expected to know the truth of the matter. Unlike modern juries who are expected not to know anything except the evidence that's presented to them, these juries were expected to know the answer, and that's why they were being asked. And there were more than one person just so that you make sure that there wasn't like just some bad feeling between someone, and so they were giving the right verdict. During the remainder of Henry II's reign, heirs were sent out at pretty regular intervals, as there was seen to be a need. He also established a royal court that sat at Westminster, presided over by prominent men he appointed, even when he was absent. And sometimes he went out of the country and he had this court sitting at Westminster, so people who felt they had been mistreated in other courts could come there, and etc. All of his royal courts began to keep written records of their decisions. These records allowed for the establishment of legal precedent, and so for the development and elaboration of the common law. Okay, so we're moving on to the 13th century, the era of the charters, Magna, and otherwise. The Magna Carta and the following charters and provisions, because there are a bunch of them, further organized the English legal system. Not only did it establish Parliament, it expanded the use of juries in the guilt phase of criminal matters. This was especially important because in 1215, the same year as the Magna Carta, the Pope decreed that the clergy could no longer oversee ordeals, and which was important because the idea of the ordeal was that God was going to decide the question. So if you don't have a priest there to bless things, it's not going to work. So suddenly the only way to determine the truth or falsehood was with the jury. So luckily they had just been introduced. Guilt juries were still expected to know about the incident, but could not have been on the jury of presentment, the grand jury that indicted the people. The wanting to turn to juries reflects the Magna Carta's focus on the needs of the nobility, as regular criminals often preferred trial by ordeal, since the criminal case wouldn't have come to court unless their neighbors thought they were guilty. So they were pretty sure to be found guilty because you knew their neighbors thought they were guilty because they wouldn't have been there. But this system is the root of how juries became triers of fact, because they are assumed to know the facts. And now we say they're triers of fact, even though they don't know the fact, but that's how that started. The Magna Carta also required that the Court of Common Pleas, a Court of Common Pleas must be held at a definite place and not follow the royal court around wherever the king was. This separated the Court of Common Pleas from the Court of the King's Bench. So common pleas are pleas between people who are not tenants in chief that don't directly concern the king. And the King's Court heard cases where it's thought to directly concern the king. That includes criminal cases, because that's a disruption of the king's peace. This made Westminster, which was already becoming the central administrative center of the country, because the exchequer stayed there most of the time now, also the legal center of the country. Action in these royal courts could only be initiated by writ. Each court had specific writs that brought matters into them. They only heard certain kinds of writs. At first, there were a few sorts of writs, and only those very specific things could be addressed by the royal courts. Over time, the number of different kinds of writs multiplied. By the end of Henry II's reign in 1189, there were only about 15 sorts of writs that could be returnable, that were returnable to royal courts. By the 1250s, there were 40 returnable to the central courts and 19 to the county courts. 20 years later, there were 65 returnable to the royal courts and 20 to the county courts. This despite the provisions of Oxford in 1258, requiring the agreement of the King's Council for any new writs to be created, because they were proliferating so fast and people couldn't keep track of them. Since these set writs were the only way to pursue litigation in the King's courts, finding a way to fit the problem at hand to an available writ became a complicated and torturous art form. Additionally, writs had a set form and specific language. Further, once in court, the pleading had to be conducted with very specific wording and in law French, whereas the writs are written in Latin. So as litigation increased and with the advent of new legal records, and so a body of legal precedent, men of law began to appear about 1200. Some worked as what would become solicitors, called attorneys at the time, often members of great households. You know, a earl might have an attorney just in his household to do all his work, and often clerics. They kept track of legal matters for their lords. At about the same time, another group appears, the countors or narrators. They appeared in court to make pleadings in cases. Pleadings were called counts or narratios, which is why they had those names. At first, while narratore assisted, they would stand next to you and give your pleading while you stood there. They spoke for you because the wording had to be just so. It was nice to have somebody who really knew how to do those pleadings so they wouldn't mess up. If you left something out, you know, your pleading would fall. So it was useful to have them. But pretty soon, the narratores could represent you in court, so you didn't have to show up in civil matters. Okay, and pleadings were not like pleadings now, where you just set out all the facts of the case for the jury to decide. The point of pleadings at this time was to discover an issue. An issue is a question that can be resolved with a yes or no answer. That is the crux of the case. And you arrive at that by having pleading and counter pleading, where the plaintiff says what he thinks has happened, and then the defendant denies all or some of the charges. And if he denies all of it, then you have a question that can be answered, right? Yes or no. Is he guilty of all of this or not? But if he says some of that, or he says, well, but really this is a whole different thing, then you have to argue back and forth until you arrive at something where the answer is either yes or no. Because the juries can only answer clear yes and no questions. So one of the things lawyers did was figure out how to word their pleadings so they would, when they came down to the question, it was one that the jury couldn't misunderstand. so that they could get the proper verdict for their clients. And these, in the trial by battle was still practiced for civil cases at this time. It wasn't, the ordeal had been done away with for criminal cases, but there was still trial by battle or jury for civil cases. Oh, I'm glad you find it fascinating. That's good. I do, and I'm not, so there you go. By the middle of the 13th century, there was a well-established group of natatories, about 30 or so, who made the vast majority of the pleadings in the major courts. These guys came from the middling sort. They were not clerics, they were not in holy orders. They tended to be like the younger sons of minor knights or prosperous merchants, or sometimes even, just freedmen. They made a lot of money. A few of them worked exclusively for a single nobleman. That was not usual. I suppose some of the great earls might have had a narratore just to do their work because they had so much, but mostly they took retainers from several great men. And so what they would do, this guy's work one day and that guy's work another day. So this was a very early source of social mobility. These people made a lot of money and they became great families because of it. You've probably heard of the Pastons. They've got a famous set of letters. Their rise to prominence started with an attorney, well, not an attorney, a barrister in the family. So it was the start of many a great family. And soon judges tended to be chosen from among this group of guys, which was another way to rise in status because central court judges were normally knighted when they were assigned to the bench. That's why to this day you call it Judge, Sir, and Your Honor, because they're knights. Through the 13th and 14th century, the basic structure of the legal system continued and elaborated. Heirs were sent out on a pretty regular basis, notably when the king needed money. The heir of 1258, fines and the fees associated with processing cases. The heir of 1258 netted King Henry more than 4,000 pounds, which was about 1/8 of his total yearly income. The only king who didn't do that was John. He didn't send out heirs very frequently, hence the Magna Carta. So he also abolished that central court at Westminster, which is why there's a clause about it in the Magna Carta. Eventually, in 1273, regular assize circuits were established. In an assize circuit, at regular intervals, a pair or trio of judges were appointed to a set route with a prearranged court days in towns around the country. Hundred and county courts continued to handle minor local matters, but referred major matters to the assizes. In criminal cases, particularly cases that could end in hanging, county courts didn't do hangings, assizes did hangings. Manor courts continued to operate more and more, just handling peasant tenure, because peasant tenure was controlled by customary law, and so it didn't go into the higher courts. Writs were developed that allowed cases to be removed from local courts into the royal courts. And this became so common that cases below a certain value could no longer be taken to the royal courts. In civil matters, this was really because a big civil case often was resolved by trial by battle. People had champions, religious houses had champions in case they had to have a trial by battle. But at the assizes, you could choose to have a jury instead, which was a real advantage to the royal courts. The number and type of writs expanded and pleadings became more elaborate and varied. By 1300, narratatories were organized with a training system for apprentices. There were published volumes of acceptable writ forms, as well as model pleadings. There was also an organization of elite practitioners who were allowed to appear before the Court of Common Pleas, which was by far the most busy royal court. They were called the sergeants at law, with membership appointed by the king, usually in batches of about 5 to 6 by the year. They had special outfits. The order was called the Order of the Coif because they wore a white linen coif. And they usually wore parti color and by the 15th century, the parti color had blue stripes on one side. Both the parti color and the coif signaled that these were lay people, not clerics, which had been usual in court up until that time, because clerics can't wear coifs or parti color. So there's I put a handout on the thing. There is on the handout, there is a URL for the Inner Temple Library that has the earliest depictions. There are 4 illuminations of the royal courts. They're from the 15th century. They're the earliest depictions of courts in England. And they're very lovely. So if you get the handout, it's worth going to look at the pictures. By the middle of the 14th century, royal judges were almost without exception chosen from among the sergeants. Sergeants were also often appointed to the assize circuit to ride as judges. In time, and this is mostly later into the 15th century, the sergeants' exclusivity proved their undoing. They were expensive to hire. And so litigants and the whole process was very complicated in the Court of Common Pleas because it was the busiest court. It was jammed up and it was hard to get a court date. So litigants began to find ways to take their suits to other courts, notably the Court of the King's Bench, where they could employ barristers, men who had graduated from training, but had not as yet been called to the coif. So they were sort of sergeants in waiting, but after a while, people just became barristers and never became sergeants, and there were a lot of barristers going around. In a side note, this King's Bench thing is the reason that civil actions are known as torts, because in order to get them into the King's Bench, they were brought in with a writ that alleged a breach of the King's peace. Pleadings to this writ had to include this breach of the peace with the words tort et force in law French. Thus, they started to be referred to as torts. Over time, the barristers outstripped the sergeants at law and became the main trial lawyers. Barristers banded together to live in hostels in London because often they had country homes and they would stay in London when the court was sitting. And so they had these hostels or inns. And over time, they found inns that had rooms where they could hold training for the apprentices. And those became the Inns of Court, which still operate today in England. The inns were mostly named after the great family who built the townhouse where they were located. So Lincoln Inn and Gray's Inn. The exception is Temple Inn, which is where the old Templar church was, which tells you when it was established, because of course the Templars were dissolved in I think it's 1306. And so it's right around that time that these Inns of Court are being established. And so there was all this property going wanting, so they grabbed it and used it for their Inn of Court. Interestingly, none of the lawyers, attorneys, sergeants, or barristers were directly involved in criminal trials. Their job was to draw up legal documents and writs and argue to find the question in pleadings. They did not argue facts. Questions of fact were questions for judges and increasingly over time for juries. Criminal matters were seen as simple questions of fact, and so did not call for the help of a lawyer. And that didn't change for a long time. Another innovation of the 13th century was the making of law by parliament or statute. The first recorded statutes were issued in 1275. Soon Parliament regularly began issuing statutes which were recorded in rolls and added to the court's rolls of judgment and case books as comprising the common law. It's funny to think of a time when Parliament didn't make statutes, isn't it? The 15th century was a time of great upheaval, the Wars of the Roses, I'm sure we've all heard of. And during this time, the common law courts kind of fossilized. There was a saying about the law at that time, no writ, no remedy. Judges had entirely removed themselves from any question of decision on merit and confined themselves to questions of procedure and quibbles about form. There are people who had their cases thrown out because they misspelled something in a writ. There was a criminal case that was thrown out. There was a criminal conviction that was thrown out, murder conviction was thrown out because someone had left an I out of the writ that followed, the writ of mandamus that we still have now. But the pleadings had become ritualistic, the writs had become ritualistic, everything was fossilized and very specific. And the law was very expensive and the solutions were unsatisfactory. One interesting innovation that happened, there was the introduction of written pleadings. Previously, pleadings had just been made orally in court, but now people wrote them out and they could exchange them ahead of time. And so they could sort of start to figure out what that question was and also figure out if they needed to use a different writ. And often the pleadings then would precede the writ, which was new. Some ingenious ways were found to avoid or mitigate some of the problems that the legal structure at that time brought about. An example you have probably heard of is child marriage. In histories, you read about couples being married as very small children, and sometimes nothing seems to come of it. You read that they married so-and-so, and then later on they marry someone else, and there's never any explanation about how that happened. This is because child marriage was in fact a sort of insurance policy against the terrifying possibility of wardship. If a minor heir was left without a parent or guardian, their property, person, and choice of marriage partner was automatically given to the king. The king could then give or sell the wardship to someone who would have control over all the ward's property until they were of age or married. The ward owner could strip their woods, overgraze their field, do anything they wanted to, marry them to some horrible person, and there was no recourse. They were your guardian, there was nothing you could do. Great estates could be laid waste by a wardship. To avoid this, families used child marriage. Marriage at this time had several stages. There was the contract and financial statements, there was the promise to marry, and then there was consummation. Children could be contracted to marry with agreed settlements. Thus, if the parents died, the wardship would automatically go to the spouse, and if the spouse was still a minor, to their parents. And those parents had an interest in keeping their property whole because it was going to go to the spouse of their child. And then if the parents lived until the children were old enough, the marriage could be blessed and consummated if it was still wanted, or it could be dissolved by mutual agreement because it hadn't been consummated yet. That's where I don't know if you've heard the term wedded and bedded. That's because until the bedding, the marriage is not actually solid and absolutely certain. So a similar sort of trick or another trick was developed to avoid death duties on land. By this time, freeheld land, i.e. land not held in peasant customary tenure that was overseen by the manor courts, was treated pretty much as if it were owned. Land was sold and rented. Old feudal obligations only remained in some vestigial forms, and one of these with death duties, which is the payment due the feudal overlord when the title transferred to an heir. These payments were onerous. People came up with the idea of giving title to their property to a trust, a group of men, usually attorneys, who could appoint replacements to the group. So the group never ended. And since it never died, the title never transferred. The trusts were written so the original owners had the inheritable right of the use of the land. By the 16th century, many, if not most, large landholdings were technically owned by the trusts. There were a bunch of trusts and there were no death duties. Henry VIII had a lot to say about that. Trial by battle in civil cases continued to occur with champions until 1485, which was the last recorded case. In general, the law was best avoided in the 14th century. The courts themselves became embroiled in the political upheavals, with juries and judges allied with one side or another in the Civil War. And judges were famous for receiving gifts from rich men so that poor people felt they had no chance. And at the same time that the Civil War was wreaking havoc among everybody, everybody in the land. And so I could now move on to the Tudor courts, but I think it's probably time for me to ask if anyone has any questions. And I will say this. What happened at the beginning of the Tudor period is that people began to turn to the equity courts, the Court of Chancery and the Star Chamber. And these were courts that didn't follow the common law, but instead were based on the idea of the curia regia being the fount of justice. And that was seen as the sort of the solution to this, because you could appeal to the king when a miscarriage of justice had happened, even if it was legal. So, you know, like if the law didn't cover what you were what the problem you had or something, it could be solved that way. Oh, but the handout, I put it, I think there's a Google Drive on the RUM site. And yeah, and you could get the handout is there.
And I know that they're going to link those handouts as well when they take the recordings and edit them. They'll usually put those in the links as well.
And the URL for those really great illuminations is in the handout as well. It's really lovely. They have really strong protections on them. They don't let anybody reproduce it. So I couldn't reproduce it and bring it, but it's worth looking at if you're interested in these things. So does anybody have a question or wants me to expand on anything?
Yes, I have a question.
Okay.
So in these proceedings, this is kind of an odd opposite because you were talking about the procedure. What about witnesses? Did they, I mean, I happen to know a little bit about court systems outside of, well, like the German system.
Yeah.
The witnesses would face the judge where.
No, there were no witnesses.
There
right?
Okay.
There were no witnesses because juries were essentially witnesses themselves.
Okay.
Right? They were supposed to know what happened. And in civil cases, it was a question of finding the question, which could then be taken to a jury. So the juries only happened at the assizes. So in the central courts, they would argue the question until they got down to the yes or no question that I talked about. And then it would go out either to battle or jury. And they would answer the question. So there wasn't a witness. There wasn't evidence as such. It was just the pleadings, which is the arguing to try to come to this yes or no question.
I think it was after the 17th, 18th century before Europe started getting witnesses in the courts then?
Well, I don't know about Europe because I'm all England all the time.
Okay.
I think that evidence started coming in actually under the Tudors a little bit.
Okay.
But it wasn't until much later that it really, as we understand it, that evidence was taken during court cases.
Okay, thank you.
You're welcome. Any other questions? No? Well, I'll tell you this is a fun Tudor fact. So it's outside of the scope of the class, but I'll tell you a fun Tudor fact in the couple minutes I have left. Cardinal Wolsey was famous for misusing those equity courts because the equity courts had a lot more leeway. They weren't confined by common law. And he was like throwing people in prison and seizing their property and all kinds of stuff all the time. And it is believed that our writ of habeas corpus came as a direct response to his depredations. Habeas corpus at that time was a writ that was returnable to the King's Court, which is a court of common law where there are all the rules and procedures we're talking about. And it meant that they could bring in people that had been falsely imprisoned and have a hearing about that in the King's Court, subject to the rules of the common law. And I thought that was kind of interesting, so I'll just tack that on here. And I think I should end now because probably people need to go to other classes. Unless anybody has a question, I'm happy to answer it. And if anybody, on the handout, there is also my email address. And if anybody, wants to geek out more about this stuff, feel free to email me. I love it, as you can probably tell. So please feel free to contact me.